Let's go to John. John, you're on News Radio WFLA. Go ahead.
Yeah, hey, good morning, Tom. Question regarding a will and inheritance of a residence. My mother-in-law, my wife's mom, 89, widow, excuse me, is bequeathing her residence to my wife in her will. She's in good health, and we hope and expect that she'll be around for many more years. But we're looking at a ladybird deed, or perhaps even an earlier quitclaim, because ladybird doesn't kick in until after she passes. The idea behind the quitclaim would be to allow her to, my wife, to invest in the property or improve it and do, further maintenance or things like that. At 89, my mother-in-law is somewhat reluctant to do. The property's in good shape now. It's well valued, and so the question really has to do with quitclaim would inherit or take on possession of the property early, and then would have an agreement that she would live there, as long as she's capable of living by herself. And what are the implications of that from a tax perspective? I have other rental property, and I thought, well, this may have some advantage in that regard.
Well, what you really are looking for is what's called a step-up basis, so that when mom passes away, your daughter's basis for capital gains tax purposes will be the value at the date of mom's death. The ladybird deed will get you that step-up basis. That's a good thing. If mom adds daughter's name to the deed, your wife will not get a step-up basis when mom passes away. So that would be a bad thing. Now, under normal circumstances, I would certainly recommend a ladybird deed. But if your daughter is getting ready to dump a bunch of money into this house, I can understand why your wife wants to be protected. And so there might be a middle ground here, and that is that your mom could do what I would call a life estate deed. That deed would grant mom a life estate in the property as long as she's alive. She gets the use and benefit of it. And then a remainder interest to your wife. And under those circumstances, mom has the absolute use of the property during her lifetime, and upon mom's death, it would automatically go to your wife. No headaches, no hassles, no probate, and your wife would get the step-up basis, and that life estate deed is written in stone so that mom would not be able to let her sell it or change her mind or give it away to somebody else other than your wife.
Interesting. Yeah, had not considered that third option.
Yeah, I think that would... Normally we use an ordinary life estate, as ordinary ladybird deed, but again, if your wife is going to be dumping money into this house, the ordinary life estate deed would be a good choice for you.
Okay. Who would I talk to in your office to maybe make an appointment to come by and vet that in some detail?
Well, it'd be me. I'm attorney Tom Olson, and
okay.
You don't need to come by and see me. Just call me next week and we can chat about it on the phone some more.
Super.
Okay, John.
Okay, Tom. Appreciate it. Thank you.
You're very welcome. Bye-bye. Chrissy, we do, most of the times we do a ladybird deed, and that ladybird deed states as long as mom is alive, it is her house to do with as she pleases, and upon her death, the home goes to the children. No headaches, no hassles, no probate. And that allows mom to change her mind at a later date. If mom does a ladybird deed today and she leaves it to her 3 kids, and 6 months from now she has a falling out with one of the kids and wants to change it to 2 kids, or 6 months from now she wants to sell or refinance the home, she can certainly do that without the children's knowledge, signature, and consent.
Exactly.
Yeah.
But there are certainly circumstances such as this possible unique situation that the traditional life estate would be better. And knowing that it's only going to daughter, whether it's the traditional life estate or the ladybird deed, either way, daughter gets it. But like you said, this just gives daughter a little bit additional protection, but also remains to get the step-up basis. So in this unique set of circumstances, that would be the better tool.
So sometimes people ask me, Tom, when do people do a traditional life estate deed? I had one example of it, but now after this call from John, I think I got 2 examples of it.
I agree.
But the one example of it that I normally give people would be this, is that a few years ago, people are always coming by and knocking on elderly people's doors and say, hey, would you like me to put a coating on your driveway, or would you like me to go check out your roof? Here, sign this form and I'll do that for you. And that form turns out to give the contractor, the scammer, a lien against the property for putting some tar down on the driveway. And, next thing you know, mom owes $15,000 for this very shoddy job of what they just did. They were concerned because that had happened to mom. They didn't want it to happen again. So we did a traditional life estate deed so that mom could not put any more liens against the home without the joinder and consent of the kids as well.
Absolutely. You're correct. It is a way and a tool to be able to help in that situation, of course.
So, in that situation, mom and the kids, they were all in my office. I kept looking at mom. I said, look, you need to understand. You signed this. It is written in stone. There's no changing your mind. She got it, and she was in agreement to it. In this situation, John is saying, hey, my wife is about to pour a bunch of money into this home. We want to make sure that she gets it someday. I can understand why we might use a traditional life estate deed for that purpose.
Exactly. So I think that this is a perfect example of the tool working beautifully for this set of circumstances. And you're absolutely right. I just was dealing with a situation with a client where the elderly mom, she did have it where she signed something. And again, this was they did not come to us, meaning prior. This is now after the fact. And unfortunately, elderly mom did sign something where, listen to this scam, they installed a new HVAC in the agreement that mom signed. Not only did it give them a right to do a lien, it also said right in there she was renting it.
Oh, my goodness.
She didn't even own it.
Oh, boy.
And the end of the day, they did put a lien. And for a $5,000 HVAC unit, they ended up charging $35,000. Now, the reason how we were dealing with it is because of the probate.
Yeah.
So now they're trying to, now the probate is completing. They're going to sell it, and they've had to pay that.
What a shame.
Isn't
so
that
many
a shame?
people out there trying to rip people off. It's
Isn't
really
that sad?
just,
It's just, it made me think of it because
Yeah.
you said that, in other words, be aware, because I'm hearing other situations of these HVAC where they're coming around and it's sounds like a great deal. When you read the fine print, which then they sent me the contract and I read it and I was like, oh my gosh, this says that she's renting it.
Hey, folks, we're the Olson Law Group, and we assist clients throughout the state of Florida with wills, trusts, probate, helping to protect people, protect their life savings from nursing homes. You can call us anytime at 407-423-5561 or check out our website, olsonlawgroup.com.